Subscribe. Lokpal and Lokayukta Amendment Act, 2016. After the introduction of the Lokpal and Lokayukta Act 2013, a bill was passed by Parliament in July 2016 which amended the Lokpal and Lokayukta Act, 2013. This amendment enabled the leader of the single largest opposition party in the Lok Sabha to become a member of the selection committee in the absence of a recognized leader of opposition. This bill also amended Section 44 of the Lokpal and Lokayukta Act 2013. Section 44 of the Act dealt with the provisions of furnishing of details of assets and liabilities, within 30 days of joining the government service, of any public servant. This amendment replaced the time limit of 30 days. It stated that the public servants will make a declaration of their assets and liabilities in the form and manner as prescribed by the government. In the case where any non-governmental organization receives funds of more than 1 crore rupees from government or receives foreign funding of more than 10 lakh rupees, then the assets of the trustees and board members were to be disclosed to the Lokpal. The bill provided an extension to the time limit given to trustees and board members to declare their assets and those of their spouses. Structure of the Lokpal. Let us try to understand the structure of the Lokpal. Lokpal is a multi-member body consisting of one chairperson and a maximum of 8 members. The person to be appointed as the chairperson of the Lokpal must be either the former Chief Justice of India, or the former Judge of the Supreme Court, or an eminent person with impeccable integrity and outstanding ability, who must possess special knowledge and a minimum experience of 25 years in matters relating to anti-corruption policy, public administration, vigilance, finance including insurance and banking, law and management. The maximum number of members must not exceed 8. These 8 members must constitute half members to be judicial members. Minimum 50% of the members should be from SC, ST, OBC, minorities and women. The judicial member of the Lokpal must be either a former judge of the Supreme Court or a former Chief Justice of the High Court. The non-judicial member of the Lokpal needs to be an eminent person with flawless integrity and outstanding ability. The person must possess special knowledge and an experience of a minimum of 25 years in matters relating to anti-corruption policy, public administration, vigilance, finance including insurance and banking, law and management. Term and appointment to the office of Lokpal. Lokpal chairman and the members can hold the office for a term of 5 years or till they attain the age of 70 years, whichever is earlier. The members and the chairman of Lokpal are appointed by the president on the recommendation of a selection committee. The selection committee consists of the Prime Minister of India, the Speaker of Lok Sabha, the Leader of Opposition in Lok Sabha, the Chief Justice of India or any judge nominated by Chief Justice of India, one eminent jurist. The Prime Minister is the chairperson of the selection committee. The selection of the chairperson and the members is carried out by a search panel of at least 8 persons, constituted by the selection committee. Lokpal Search Committee. As per the Lokpal Act of 2013, the Department of Personnel and Training needs to create a list of candidates who are interested to become the chairperson or members of the Lokpal. The list was then to be presented to the proposed 8-member search committee. The committee on receiving the list shortlists the names and places them before the selection panel, headed by the Prime Minister. The selection panel has discretion in selecting the names from the list presented by the search committee. In September 2018, a search committee was constituted by the government which was headed by former Supreme Court Judge Justice Ranjana Prakash Desai. The Lokpal and Lokayukta Act of 2013 also mandates that all states must set up the office of the Lokayukta within 1 year from the commencement of the Act. Jurisdiction and powers of Lokpal. The jurisdiction of Lokpal extends to Prime Minister, Ministers, Members of Parliament, Groups A, B, C and D officers, officials of central government. The jurisdiction of the Lokpal extends to the Prime Minister, except in the cases of allegations of corruption relating to international relations, security, the public order, atomic energy and space. The jurisdiction of the Lokpal does not include ministers and members of parliament in the matter relating to any speeches delivered in the parliament or for a vote cast in the parliament. Lokpal's jurisdiction also includes Every person who is or has been in charge, director, manager, secretary, of a body or a society set up by the Act of Central Government. Any society or body financed or controlled by the central government. Any person involved in act of abetting, bribe giving or bribe taking. The Lokpal and Lokayukta Act states that all public officials need to furnish their assets and liabilities as well as their respective dependents. The Lokpal also possesses the powers to superintendence over the CBI. It also has the authority to give direction to CBI. If a case is referred to CBI by the Lokpal, then the investigating officer in such a case cannot be transferred without the prior approval of the Lokpal. The powers of a civil court have been vested with the inquiry wing of the Lokpal. The Lokpal also possesses powers regarding the confiscation of assets, proceeds, receipts, and benefits arisen or procured by means of corruption in special circumstances. It also has the power to make recommendations regarding the transfer or suspension of public servants connected with the allegations of corruption. Lokpal is capable of giving directions to prevent the destruction of records during the preliminary inquiry. Limitations. The institution of Lokpal came up as a much-needed change in the battle against corruption. The Lokpal was a weapon to curtail the corruption that was spreading in the entire administrative structure of India. But at the same time, there are loopholes and lacunae which need to be corrected. The appointing committee of Lokpal consists of members from political parties that put Lokpal under political influence. There are no criteria to decide who is an eminent jurist or a person of integrity, which manipulates the method of the appointment of Lokpal. The Lokpal and Lokayukta Act 2013 failed to provide any kind of concrete immunity to the whistleblowers. The provision related to the initiation of inquiry against the complainant, in cases where the accused is found innocent, leads to discouraging people from making complaints. One of the biggest lacunae is the exclusion of the judiciary from the ambit of the Lokpal. The Lokpal does not have any constitutional backing. Also, there are no adequate provisions for appeal against the actions of Lokpal. The states have complete discretion with respect to the specific details in relation to the appointment of Lokayukta. The need for functional independence of the CBI has been catered to some extent by the change brought forth in the selection process of CBI's director by the Lokpal and Lokayukta Act. The Lokpal and Lokayukta Act also mandates that no complaint against corruption can be registered after a period of 7 years from the date on which the mentioned offence is alleged to have been committed.